People's Republic of China, the United States, and Brazil. And it was astonishing to me. We were able to enforce it in China faster than we could get a scheduling order out of the United States. And the Brazilian courts told us, our counsel there said that unless we got this sort of summary proceeding, which effectively no one ever gets, it was likely to be 5 years before we got an award out of the court of first instance.
But now, was this enforcing an award, an arbitration award, opposed to because if you had a court judgment, it would have been a much more complicated, much less certain process.
It goes faster. About having tried to enforce international arbitration awards, sometimes it depends on what you're taking to enforce them. Because the local
but even within China, we were in the intermediate court in Beijing, which is very, very good, very, very tuned into this. We were, if we'd been in, Chongqing or Guangzhou, would have been longer. If we'd been even further in the hinterland, it might have been never.
Let me take this again back to the commercial folks who are negotiating these contracts, and let's take our hypothetical one step further to a much more difficult scenario where now we're selling to a Russian company, I don't know, say in Kamchatka or someplace, or an Indian company or a Nigerian company, and they don't want to litigate in the U.S. courts. So dispute resolution in the Southern District of New York is not acceptable. They're not looking at London either. They think that London might be very expensive. They have maybe a state-owned company, a mandate not to accept expensive dispute resolution. And they want dispute resolution in Russia, in India, or in Nigeria. Maybe the first question is, do you do the contract?
I mean, are we talking?
Serious question.
They want court litigation in that place?
In India?
Well, they would want dispute. They are happy with court litigation. They tell you.
Yeah,
but maybe they're open to something else. But the question is, even if you can have arbitration, let's say in Moscow or in Delhi or Mumbai or in Lagos, arbitration side there, is that something that's even an acceptable alternative?
There's a specific application for that. I'll give you the Indian context. This comes up quite a lot. There was a great deal of concern about again, this comes back to enforcement, about the ability to enforce an international arbitral award rendered outside India, in India, if that award was governed by Indian law, which a lot of the national law companies required. The solution that most people hit upon is to say, okay, fine, we will accept to arbitrate in India, but we'll do two things. One, we're going to make sure it's an international institution. In this case, it was the LCIA. The arbitrators will be not the nationality of the party, so we get away from Indians. We will agree, and we took some measures to prevent the perennial problem in India, which is anti-suit and anti-arbitration injunctions. And every different country has its own problem you have to build for. So you have an arbitration that's international, it's in India. It satisfied their need to be in India because it was under Indian law. It made it more enforceable in India, where we thought we would need to enforce. But we took a lot of steps to insulate it from what we perceive to be the potential problems of being in India for an arbitration, that being the courts interfering with the process.
Right.
And did that by saying that the arbitration clause would be governed by English law and subject to the English courts, right, which the Indians were happy with.
Sounds not perfect. Sounds like a not perfect solution, but far from perfect solution. But if you really wanted to do the deal, right, it sounds like there was also a lot more lawyering. There wasn't just a standard clause that you could have adopted and say use this.
No. Exactly.
And that one requires a fair amount of. It would require a fair amount of research and
working with local counsel and something like that.
Yeah.
I mean,
so just adapting your terms, your standard terms and conditions is probably not going to work in a case like that.
Not if you're going to do something like that. If you're going to say, well, we'll do the deal in Nigeria, but we'll arbitrate in London, different issue, or Stockholm if you want a neutral jurisdiction, or Singapore. There are lots of places you can do it that are not London or New York. But if you're going to do it in one of those jurisdictions, you wind up with the problems like they had in Indonesia, where the Jakarta courts enjoin the process and kidnap the arbitrator to keep them from rendering a decision.
Very famous case in Indonesia.
One of the things you hit upon, though, is the incredible importance of planning. I think all of us at this table would agree that 90% of the arbitration agreements we write are written within sort of 24 hours of the closing. You obviously can't write those sort of bespoke clauses for the really difficult, risky situation with 24 hours notice.
Right.
It's very important that your commercial guys get in touch with the internal legal team very early on in the process if they think this is going to happen, and give you guys time to develop something, or search for somebody who may have some intellectual property.
Great point. You begin thinking as you're beginning the contract negotiations. If you're getting body language from the customer that they're in Kamchatka and they're going to insist on some form of dispute resolution in Russia, what you could, first of all, whether or not you want to do that contract, I guess is maybe you need to say for your commercial team that there might be some deals you just will not want to do because of the level of risk, or there may be some risks where the contract pays enough to accept the risk because it's a risk of enforcement. And if you're getting paid enough on the contract and you're getting paid in advance as you ship the equipment into the country, maybe you can say that's a risk I can reasonably mitigate if, as you point out, if I do my dispute resolution clause in the right way.
That's the red flags. It's an unusual country where you're going to be in the courts, or an unusual country where you're going to cite the arbitration. Anything like that should be a red flag that you need to consult the lawyers earlier in the process than if it's just LCIA or ICC in London or Paris.
Which is not the case. Obviously, if the case is one where you've got dispute resolution, no matter who the other side is, if it's a Russian company or a Nigerian company or an Indian company, if you've got dispute resolution in New York or London or Paris or Geneva, they're all jurisdictions that are highly favorable to arbitration, so you should be okay with using your standard clauses in those cases, right?
Yeah, a number of clients in the oil and gas business now have got rules for commercial negotiations that require the legal department to sign off on choice of law, dispute resolution, in any contract above a certain amount. Usually it's a fairly substantial amount, but you've got to have legal department actually agree, okay, we can accept Nigerian law, we can accept the Nigerian courts before.
What, you want to give names?
No, I can't do that. But you would recognize.
I've seen it on more than I've seen it as well. You have there's a checkbox on the face of the contract for
legal review.
You bet.
Yeah.
I mean, and because we're all from Houston, we see clients who do a lot of things in really crazy places, and that really ought to be part. If you're taking. It's not avoiding risk. Is not what business is about, right? I mean, taking risk is what business is about. Right. So you got to find the ways of managing it, containing it, understanding it.
Okay. Well, great. Thanks everybody so much for taking the time. It was a little bit longer than I told you, the 10 minutes, but I really appreciate it.
No problem.
Glad to do it.
Thank you.
You've been listening to International Dispute Negotiation. This podcast is presented by the International Institute for Conflict Prevention and Resolution, CPR. CPR is a membership-based nonprofit organization that promotes excellence and innovation in public and private dispute resolution, providing an international resource for the avoidance, management, and resolution of business disputes. For further information about CPR, or to download archived versions of this podcast, go to www.cpradr.org. Questions about this podcast or the issues discussed can be addressed to idn@cpradr.org. The music of Note Noir is used with permission.